Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nicholas Rekieta. I'm a lawyer in central Minnesota. I run my own practice that is Rekieta Law. So if you're ever in Minnesota and you get into legal trouble, let me know. Look me up. Moving on from that. What I do on this channel is what we do together. We are unified in this endeavor. We go through a legal ruling or a case, as it were, in many instances, one line at a time, generally speaking. And I translate the legal language, I translate the procedure as best as I am able, and I try and give you fine folk with some idea of what's going on in these documents written in the most inaccessible foreign language that resembles English that you could possibly imagine by some of the most pretentious and overwrought writers in existence. We have our own language that we try to use to keep you guys out of our cookie jar, right? But that's not what we do here. What we do here on Lawsplaining is bring this down to a reasonable level and look at it with the understanding of a normal human being. And sometimes we do that with whiskey. And tonight is one of those nights. What I've got tonight is the last bit, probably, of this whiskey from the 45th Parallel Distillery. This is a wheat whiskey. They're in Wisconsin. I got these for my birthday, and they were purchased at a charity auction, and they're very, very good. I really am a big fan of this distillery and their products. If anybody's watching, look me up. I'd love to talk. So, before we get started, cheers. All right. What we are talking about today, this is I don't know what this is, the 6th, 7th video? 5th? No, I did the 5th one. I did one that was out of series, though. I don't know, something like the 6th video in my ongoing series on the James Damore versus Google class action lawsuit. And just a couple days back, this is dated January 16th, but the opinion was not released January 16th. This was released in February. I don't remember the exact date. It's now February 20th, early AM, and I think this was released on like the 16th or 15th, something like that, because I've been aching to do a video on it, but I have been unable to due to other obligations. So now we're going to go through this. There have been plenty of commentaries about this from people who are not lawyers, looking at this from a policy perspective and all that. But I'm going to break it down on the legal level. So please, if you think someone would find this interesting, if you know people like I do who are kind of obsessed with this case and really want to know what's going on, share this video with them and let them tear it apart. Maybe they think something entirely different from me. And that is great. If you do, tell me about it in the comments, and we'll talk about it like people. So let's get started. So first, what is this? What is this? So we know James Damore filed a class action lawsuit in California. That is under California state law. It will be decided in the courts of California. Both James Damore and Google are residents of California, and therefore the California courts have jurisdiction over their employment matters. However, the National Labor Relations Board also has jurisdiction in labor cases over pretty much anything, and people who believe that their labor rights specifically have been violated can petition the National Labor Relations Board for some relief. Damore also did this in conjunction with his case class action lawsuit. Now, I have seen it nebulously reported that he has lost his case against Google, which is not true. His class action lawsuit, which is a much more important case than this ruling, is still intact and is still before the California court. And this has nothing to do with that on a real legal level. Now, there may be some practical implications and motivations behind issuing this ruling in this way, and we'll talk about those as we get there. But so this ruling is the result of that petition to the NLRB by James Damore. Now, this ruling is, before we get confused, this is not a ruling from a judge. This is an opinion, an advice memorandum from the Office of the General Counsel of the National Labor Relations Board. So the person who wrote this is Jamie L. Saphir, Associate General Counsel, Division of Advice. Jamie L. Saphir is an attorney who would argue cases on behalf of the NLRB, for example. Actually, probably not, since she's in the Division of Advice. She would render these advisory opinions, and what they do with these advisory opinions is the central office of the NLRB would send this advisory opinion out to the board, the regional board, oh my goodness, the regional board of the NLRB that would be in various regions. In this case, Region 32, which would be in California, and would oversee labor issues in a more localized way, right? You can't just have everybody running to Washington, D.C. for this. It's much more efficient, I suppose, to have a regional office, even though nowadays all of this stuff is done online, so there's no reason to have regional offices in that theory, although it is nice if you have a hearing to go in front of someone who's close by. So this is not a binding ruling. This isn't even a ruling. This is an advice memorandum. The reality is that the regional director, Valerie Hardy Maloney, would probably take this and issue a ruling consistent with this opinion. But that does not mean that it is correct. That does not mean that it's a judicial ruling, and there would be potentially judicial review of any ruling. But this is all irrelevant, because when this, presumably, I haven't really found out the exact date, but presumably when this advice memorandum was rendered, Mr. Damore withdrew his National Labor Relations Board petition, and it renders this basically impotent. I mean, there's no point. The matter is withdrawn from NLRB, and in a lot of ways, this matter didn't belong with NLRB. If you're not familiar with the Labor Relations Board, they typically deal with unionizing issues. And as we're going to get to, at the end of this first paragraph, they talk about Section 8A1 of the Act. Well, the Act is the National Labor Relations Act. Section 8A1 is a prohibition on employers to interfere with, restrain, or coerce employees in the exercise of rights guaranteed in Section 7. And those rights are rights around organizing, typically organizing a union or something that looks like a union for the purposes of mutual aid and protection, as listed here. Now, James Damore was not trying to unionize Google, and I believe he was operating, when filing this petition, he was operating under the idea that since his class action lawsuit involves classes of people, namely conservatives, Caucasian, and Asian men. So conservative, Caucasian, and Asian men are the protected classes in the class action lawsuit. I believe what he was trying to do was operate under the theory that his memo was an appeal to similarly minded people to create a class of people in Google that would then be insulated from termination or disciplinary actions simply for their political belief, their gender, and their race. I don't think that that was his initial intent with the memo, but I think that was his intent in filing the petition to the NLRB, and that's how the NLRB has to look for things. So let's be very clear about something. This probably didn't belong in NLRB from the first place. It doesn't mean you don't bring it. Sometimes you bring actions in multiple venues, even if the theory is a little thin, because if you get traction in that venue, you may win, right? And if he did win here, it would be a big win. But it probably really didn't belong here at all. But nevertheless, NLRB heard it, and they have issued this opinion, and this opinion is frustrating. It's very frustrating, actually, to me. Maybe it's not frustrating to you. But I think the ultimate answer is, let's go through it, and let's see what it says. Enough of my introductory rambling. So, I'm going to read through it at a decent clip, and I'm going to comment where it matters. Now, you'll see these little blacked out boxes. These are federal. So this is a Freedom of Information Act request that got this memorandum released. So these are redactions. These are the sections of the whatever code is used for redactions. Generally, it says a name or some sort of identifying information that is not necessary. I'll drop them in when I know them. Like this first one is Damore, James Damore. You'll notice his name is not on this memo. His name is not on this menu or this memo, and it is always redacted. But that's why. Privacy purposes under the Freedom of Information Act request. So let's get started. This case presents the issue of whether an employee was engaged in protected activity when he, Damore, circulated a memorandum in opposition to the employer's diversity initiatives that argued, inter alia, that innate differences between men and women may explain the lack of equal representation of the sexes in tech and leadership. Okay. That's probably a fair summary of what the memo was. Assuming arguendo means for the sake of argument. Oh, inter alia means in its entirety. Like that's the general, the summary of everything. All of it, its internal inclusions. I don't know. I don't know the direct translation. It doesn't matter. Let me just explain it to you. It means the general theme of what's going of everything. So assuming arguendo that the charging party, that's James Damore. James Damore is the charging party because he brought this motion to NLRB. Charging party's conduct was concerted and for the purpose of mutual aid and protection. So again, they have to assume for the sake of argument that his conduct was concerted and for the purpose of mutual aid and protection to even be heard by NLRB. When they say assuming arguendo, it's not clear from its face that that's what he was doing, but taking on the argument in this way. They don't have to reach this. This is an advice memorandum, and the board itself could simply say NLRB has no place here if they were ruling on it, but they're not. We conclude that the memorandum included both protected and unprotected statements. And the fact that there are unprotected statements, just as a general thing, starts to rustle my jimmies from the get-go. I'm not a fan of the idea that there is unprotected speech. I get it. You can't yell fire in a crowded theater. Yes, very cliche. That's not protected speech because that would typically be some sort of crime at the outset. Having all speech protected doesn't mean that there's no criminal speech. There's a difference between criminal speech and unprotected speech, and maybe that's a subject for a longer video or a different video even. But just very briefly, just because something is unprotected doesn't mean it is necessarily criminal. And just because something is protected doesn't mean it's necessarily not criminal. We can criminalize protected speech if it meets the standards of strict scrutiny under the Supreme Court, which means that it is basically a compelling government interest and that it is narrowly tailored to be it's the least restrictive means of achieving a compelling government interest. But you can make protected things illegal if there's a good reason and it's the least restricted way possible. That is called strict scrutiny. It is an extremely high bar to overcome, but it is possible. Unprotected speech is not necessarily illegal. For example, obscenity is technically unprotected speech, but there aren't always laws banning every type of obscenity. Fighting words. The fighting words exception is unprotected speech, but there is not always a law making fighting words impossible or making fighting words illegal, generally because these laws become very vague and they're hard to enforce equally across different people. But that's, again, so a very brief introduction to what they're saying. Unprotected statements. I want to make it clear that unprotected statements are not illegal speech, and the fact that we have unprotected statements is offensive. To anyone who cares about the First Amendment, it should bother you that we have an unprotected statement. All speech should be protected, which means all speech should only be restricted with strict scrutiny, and that's okay. That is okay. There are compelling government interests to restrict certain types of speech, like yelling fire in a crowded theater. It doesn't mean that speech should be unprotected. It should absolutely be protected, because what if yelling fire in a crowded theater was part of an act? Then suddenly you're yelling fire in a crowded theater that has taken precautions to protect against the possible negative outcome. That speech should not be automatically unprotected. And by the way, I don't think that yelling fire in a crowded theater is actually unprotected speech. It's just a sort of idiom. It's not really an idiom, but it's just a sort of expression that we've accepted as something that's unprotected. And now I'm rambling. I apologize. And that the employer discharged the charging party solely for unprotected statements, his unprotected statements. Therefore, the employer did not violate Section 8A1 of the Act. Google did nothing wrong. That's what they're saying. To be frankly clear, I disagree, but that's okay. That's okay. We can disagree. Facts. Remember that this is called facts. I'm just kidding. The employer, Google, is a subsidiary of Alphabet Inc., a technology company headquartered in Mountain View, California. The employer is engaged in the business of developing and providing IT programs for customers, including web development services, internet-related services, online advertising technology, search engine systems, cloud computing, and related software. The charging party began working for the employer as a software engineer at the Mountain View, California campus in December of 2013. One of I don't know what that's supposed to be. Employees working on blank for the employer's blank. I believe he's working on search engine technology for the employer's search engine. The employer employs approximately 80,000 people worldwide, approximately 30 to 40,000 of whom work out of the employees' Mountain View campus. Employers, Mountain View campus. Beginning in 2017, the charging party attended various summits, trainings, and meetings regarding the employer's extensive diversity and inclusion programs and policies. During one such summit in late June 2017, he expressed his opposition to several of the employer's diversity initiatives, both in breakout sessions that were part of the summit and in informal conversations with an HR manager for his division. At the conclusion of the summit, the HR manager sought out the charging party and invited him to contact, I don't know if that's a him or her, with further questions or comments. Shortly thereafter, the charging party drafted a memorandum outlining his concerns about the effectiveness and necessity of the employer's programs, particularly those targeted for women working for the employer. Now, this is where opinion starts to allow little biases to creep in, because that's one reason that he wrote that memo. But the one reason that NLRB is not talking about here is that he was expressing concern specifically that Google's practices were not only wrong-headed, but also in violation of California employment law. And that's a pretty big deal, reporting a potential crime to your employer to make sure that the employer is within the legal standards that it is under, is generally protected activity. And they left it out of this discussion, mainly saying they're concerned about the effectiveness and necessity of the programs. And he was concerned about the effectiveness and necessity of the programs. But in the context of saying these potentially ineffective and maybe unnecessary programs might also be illegal, that's a pretty big point to just leave out. He initially shared the document with the organizers of the June summit through a feedback form they had provided. On July 2nd, he posted his memorandum in an internal employer-provided discussion group called Coffee Beans, the purpose of which is to discuss the employer's diversity and inclusion programs. So, right on subject, from July 2nd through August 3rd, the charging party shared his memorandum with other employees, often incorporating their suggestions into his memorandum. On August 3rd, he posted the memorandum to another employer-provided discussion group called Skeptics, a larger forum that provided his document with more potential readers. Around that same... Maybe I'm reading into this with my own biases, but it sounds like he's... they're trying to make it out like he's trying to get views or clicks or something like that. Maybe they're not saying that at all. As the whiskey hits the system, we'll see how unbiased I can remain. Around that same time, numerous employees complained to HR about the charging party's memorandum, and at least 2 female engineering candidates for employment withdrew from consideration, citing the memo as their reason for doing so. Okay. Is it? Is that the reason? I don't know. Citing it. Lots of times people withdraw their employment and cite something that isn't the real reason. So who knows? I don't know. Maybe it is. Maybe they read this and were very offended. I can't imagine reading something and being that offended. Even if I think the person who wrote it is a completely terrible human being, I can't imagine that getting in the way of my employment to that degree. But that's me. That's me. Additionally, at least one employee contacted the charging party directly and threatened retaliation against him. There's a footnote here. So the employee's email read in relevant part, "You're a misogynist and a terrible human. I will keep hounding you until one of us is fired. F you." The employee was issued a final warning for sending this email. Importantly, he was not fired for sending that email. He was issued a final warning. So remember that, because James Damore did not receive a final warning. He received termination. In the version of the document upon which the employer based its investigation, the charging party posited that the employer had a left-leaning monoculture that created an ideological echo chamber where contrary viewpoints were shamed into silence. He included specific critiques of many of the employer's inclusion and diversity policies and a long list of suggestions to correct for the biases he identified. He also argued that there were immutable biological differences between men and women that were likely responsible for the gender gap in the tech industry at large, and at the employer in particular, including inter alia. Let's clarify something here. We'll call this our PolitiFact fact checker. He does not say that they are immutable biological differences. He says that biological differences do lead to different traits. He does not call them immutable at all. I defy you to find the word immutable in that document. But he does suggest that there are biological differences between men and women which lead to different traits. That is true. Women are more prone... Okay, so here are the statements in particular. So, I mean, I gotta, oh, hold on. Let me read the statements first. Because I couldn't, we'll talk about this in a second, but I'm kind of frustrated here, not gonna lie. Women are more prone to neuroticism, resulting in women experiencing higher anxiety and exhibiting lower tolerance for stress, which may contribute to the lower number of women in high-stress jobs. So he does say that. Now, here's one of the problems. Neuroticism is one of the 5 major personality traits that are listed in some of the psychological studies that are out there. Neuroticism is not automatically or inherently negative. There's nothing inherently wrong with being neurotic. It is given negative connotations by some people. When your neuroticism levels are too high, it can be debilitating. Just like any other personality trait. Having overly high agreeableness is extremely dangerous, right? If you're overly agreeable, you can be taken advantage of to the point where you can be manipulated into doing various things for people based on that agreeableness. So, where on earth? Let's find it. Neurotic. Here we go. Personality differences. Women on average have more neuroticism. All right. Here's what's interesting about this. So this is in blue and you guys can't see it, but this is a link to a Wikipedia article called Sex Differences in Psychology, hashtag personality traits, which would be the subheading. And this is where he got the info. Now, I went ahead and went the extra step and checked the reference talking about sex differences in psychology and where the info in the Wikipedia article came from. And it's right here. I don't have the full text because I don't think that's necessary for this type of video, but here's the title. The title is Gender Differences in Personality Traits Across Cultures, Robust and Surprising Findings. This was published in the Journal of Personal Sociological Psychology, something like that. Let's see what it says from the abstract. I'll read the whole abstract, even though I have the glaringly obvious most important part highlighted. Let's read through the whole thing. Secondary analyses of revised NEO personality inventory data from 26 cultures among 23,031 people, so pretty broad sample size, suggests that gender differences are small relative to individual variation within genders. Differences are replicated across cultures for both. So that's the first finding. So the next finding is differences are replicated across cultures for both college age and adult samples, and differences are broadly consistent with gender stereotypes. Women themselves reported themselves to be higher in neuroticism, agreeableness, warmth, and openness to feelings, whereas men were higher in assertiveness and openness to ideas. Contrary to predictions from evolutionary theory, the magnitude of gender differences varied across cultures. Contrary to predictions from the social role model, gender differences were most pronounced in European and American cultures in which traditional sex roles are minimized. And possible explanations for this surprising finding are discussed, including the attribution of masculine and feminine behaviors to roles rather than traits in traditional cultures. So, there you go. His statement is based on a published study from a scientific journal. Okay? So, yes, he cites to Wikipedia, and Wikipedia cites rather directly and rather frequently to this. So, there you go. Remember that. So the next is men demonstrate greater variance in IQ than women. This is a really interesting thing because you'll notice there's no quote attributed to that, such that there are more men at bottom and top of the distribution. Thus, he posited the employer's preference to hire from the top of the curve may result in a candidate pool with fewer females than those of less selective tech companies. Let's see. Top of the curve. Nothing. Let's see if there's intelligence. Nope. Selective? That's from the complaint. That doesn't count. Nope. IQ. There's IQ. So he says the left tends to deny science concerning biological differences between people, e.g., IQ and sex differences. He has a footnote on IQ. Ironically, IQ tests were initially championed by the left when meritocracy meant helping the victims of aristocracy. Okay. Next. So that's... I apologize that this is only... They have the Damore memo in with the complaint. So that's where those IQs were taken out of the middle of words. So if you'll notice, he references IQ once. He references intelligence 0 times. The curve, let's see. The curve is not mentioned at all. So you tell me where, in particular, James Damore is accusing Google or saying that men demonstrate greater variance in IQ than women, such that there are more men at the top and bottom of the distribution. Thus, he posited the employer's preference to hire from the top of the curve may result in a candidate pool with fewer females than those of less selective tech companies. It's not in the memo, folks. It's not there. So that statement doesn't exist in the memo that is part of the complaint, which is the final version of the memo. Maybe it's in a prior version of the memo. I don't know. I don't have that. That's the version in the complaint, I believe, is the version that was published outside of Mr. Damore's will, which we'll get to. But this whole thing isn't in the memo. Throughout the memo, the charging party included, quote, limiting language, using disclaimers such as, quote, studies show. The disclaimer is that studies, which he typically cites or often cites, I shouldn't say typically because it's not a scientific paper. It's a memorandum. But studies show. He's saying that there's an evidentiary basis for the claim. It's not just his opinion. And on average, and noting that these differences didn't necessarily apply to all individuals because they don't, but we do generalize and categorize people in large groups. On average, Americans make more money than Nigerians. That doesn't mean that every American makes more money than every Nigerian. On average, Google employees make more than the median income. But does every Google employee make more than the median income? Like a janitor or a part-time worker? I don't know. I don't know if that's true. I doubt they make more than, I doubt that every Google employee makes more than the median income in Silicon Valley. Anyway, throughout the memo, I just read that. So next, on sometime, I don't know what that's redacting, the employer determined that certain portions of the charging party's memorandum violated existing policies on harassment and discrimination. There's a footnote. The employer has a legitimate, lawful policy preventing race and sex discrimination and harassment in its workplace. Is it legitimate and lawful? I don't know if that's actually true. If it's, it may be, may not be. We have to just, I guess, assume that she read it, she being the author of this advisory memo, that she read it and concluded it to be so. But we don't get to verify it because it's not included here. Later that evening, the employer terminated the charging party's employment. Oh, this would have been August 10th, I believe. The employer terminated the charging party's employment. The HR manager and the director of the charging party's team prepared written talking points in advance, which the director read to inform the charging party of his discharge. The talking points stated in pertinent part, quote, your post advanced and relied on offensive gender stereotypes. Did it? Did it actually rely on offensive gender stereotypes, or did it rely on studies, scientific studies that he cited? To suggest that women cannot be successful in the same kinds of jobs at Google as men. That's not true. I don't think he said that ever in his memo or even suggested it. So that's great. I want to make clear that our decision is based solely on the part of your post that generalizes and advances stereotypes about women versus men. What part is that? Like they say, and there's, by the way, let me highlight that. I'm harping on this for a reason. It's going to come up later in this memo. It is not based in any way on portions of your post that discuss Google's programs or trainings or how Google can improve its inclusion of differing political views. The reason they say that, by the way, is because those two things are presumptively illegal, and the other one is presumptively not illegal. Okay, so Google is simply saying we did the legal thing, not the illegal thing. They're saying that. That doesn't mean that it actually is true. Those are important points that you made. You made important points. I also want to be clear that this is not about you expressing yourself on political issues or having political views that are different than others at the company. That's because they ran these talking points by the legal department who said, whoa, it's illegal for us to discriminate based on political viewpoint in California employment law. So you can't say that it's that. But just because they say it doesn't make it so. And that's a huge distinguishing factor. You can say you're not firing all the black people because they're black. That doesn't mean you're not firing all the black people because they're black. That just means you've come up with a different excuse. Having a different potential view is absolutely fine, except it wasn't in this case, was it? Advancing gender stereotypes is not. He doesn't advance gender stereotypes. He talks about differences that are studied or that are backed up by various scientific studies. Numerous scientific studies, if you really look at it. And, well, I don't know. This memo is not those things. I shouldn't. I'll move on. The employer's CEO subsequently sent a company-wide email. Let's talk about the employer CEO, shall we? What did the employer CEO say in a recent interview that postdated this firing? But I'm saying that representation matters, right? So the way you solve this is by increasing the percentage of women in the tech industry. That's all fine. So we need to make the environment more welcoming. We need to make the jobs more interesting. Why would you need to make the jobs more interesting to attract women if they're not biologically different than men? And then he has this offensive statement. Women typically look for jobs with a purpose. Studies show that. I think it's important for them to see why you need technology. So you have to educate women because they're not different than men, but they are different than men, according to the Google CEO. So is the Google CEO going to be fired for these statements? These statements look to be advancing gender stereotypes. The YouTube CEO right up here says, a very geeky male industry. I think it has to do with these perceptions that the computer industry is a geeky, not very interesting, not social interest or not social industries. So are you saying again that men and women are different in how they approach things? Aren't these offensive gender stereotypes? I'm sorry. I'm taking a moment because I get really annoyed. I get really annoyed when you try to couch overt discrimination with subversive reasoning, and then you have hypocrisy layered right on top of it by the CEO of Google and the CEO of YouTube, two of the highest ranking employed people at Alphabet Inc. Doing the exact thing that Damore was doing in a much more public way and everybody being just fine with it. All right. The employer's CEO, that's Pichai, that's who we just read a quote from a minute ago, subsequently sent a company-wide email that largely echoed the talking points used for the charging party's discharge. So yes, a giant propaganda campaign to talk about how they really didn't do the illegal thing. They really did the legal thing. Expressing its commitment to the dual values of freedom of expression. Does Google have the values of freedom of expression? Does it really? Does it? I don't think it. I really don't think that they can make that claim. And that's fine. They don't have to. And equal employment opportunity. Do they have that? I think a bunch of women might disagree. And I think a bunch of men, white men, might disagree right now too. The email reassured employees that the employer strongly supported their right to express dissenting viewpoints. Express dissenting viewpoints right after we fired a guy for having a dissenting viewpoint and critiquing the employer's programs, but would not tolerate arguments that advance harmful stereotypes. Although the email did not refer to the charging party by name, it referenced his memorandum. Great. Good job, Pachai. Assuming arguendo that the charging party's conduct was concerted and for mutual aid and protection, we conclude that the memorandum included both protected and unprotected statements. This is them. They had the summary up above, so that's why this sounds familiar. And that the employer discharged him solely for his unprotected statements. Therefore, the employer did nothing wrong, did not violate Section 8A1 of the Act. The board has acknowledged that it has a duty to balance an employee's statutory protected rights against an employer's legitimate right to enforce its workplace rules and managerial prerogatives. That's citing Brunswick Food and Drug. An employer's good faith efforts to enforce its lawful anti-discrimination or anti-harassment policies must be afforded particular deference in light of the employer's duty to comply with state and federal equal opportunity laws. And that's cited here. Noting that the board, NLRB, has not been commissioned to effectuate the policies of Labor Relations Act so single-mindedly that it may wholly ignore other or equally important congressional objectives. Frequently, the entire scope of congressional purpose calls for careful accommodation of one statutory scheme to another. It is not too much to demand of an administrative body that it undertake this accommodation without excessive emphasis upon its immediate task. That's an interesting citation because what they're saying is that when there's a conflict of laws, the NLRB has to weigh those two laws, right? Do we really enforce the equal employment opportunity laws, or do we enforce these other willful act of Congress? But it's an interesting citation because in this case, they're not two competing willful acts of Congress. There's one willful act of Congress, which is the Equal Employment Opportunity Act. There is not a competing will of Congress. There is a competing will of the employer to enforce an employment policy that they state is lawful. But if that employment policy is unlawful in effect, it may not be lawful. So, interesting citation. And when I say interesting, I mean terrible. Additionally, employers have a strong interest in promoting diversity and encouraging employees across diverse demographic groups to thrive in their workplaces. Sure. Does that demographic group include conservative white males or right-leaning people? In furtherance of these legitimate interests, employers must be permitted to, quote, nip in the bud the kinds of employee conduct that could lead to a, quote, hostile workplace, rather than waiting until an actionable hostile workplace has been created before taking action. Who made it hostile is always an interesting question, isn't it? Was it Damore who published a memo stating that there's science that says that there are differences, and when you discriminate against people by gender or political preference, that might be illegal? Or was it the guy who said, I will hound you until you're fired, F you? Which one of those is hostile? Which one? Where an employee's conduct significantly disrupts work processes, and if you know anything, if you've watched any of my videos, you know that there is no work process at Google because they're, according to the allegations in the complaint, basically spending nothing but time doing seminars and being on Twitter. Like, it's absurd. And the internal postings and all these email chains and discussion groups, it's ridiculous. I don't know how any work gets done at Google. It seems extremely inefficient. So saying that this conduct is significantly disruptive is a bit of a stretch to me. creating a hostile work environment. Again, when you have managers talking about blacklisting employees as alleged in the complaint, blacklisting employees for their maybe political affiliation, that seems like a hostile work environment to those employees. But are they being disciplined? Or constitutes racial or sexual discrimination or harassment. The board has found it unprotected even if it involves concerted activities regarding working conditions. For example, now listen to these comparisons, okay? Because this is a lawyer thing where you take, you have to create analogs to support your position because there isn't another James Damore at Google case. That doesn't exist. So you have to find something as close as possible to demonstrate why you have authority to rule the way you do or why you think that a board should rule in a particular way or a judge. But look at the citations they pick and you decide. I think you can tell from my tone what I think of them, but you decide if they're legitimate. For example, in Avondale Industries, the board held that the employer lawfully discharged a union activist for insubordination based on her unfounded assertion that her foreman was a Klansman. The employer was justifiably concerned about the disruption her remark would cause in the workplace among her fellow African American employees. Yeah, she said that their boss was a member of the Klan based on nothing. Like, what? Are you kidding? Is that comparable to saying there are scientific studies that suggest that there are these reasons why men and women are different, and if we take those reasons into account, maybe we can attract more women and promote diversity while not breaking the law? Because that's what the memo actually says. Next, in Advertiser Manufacturing Company, the employer lawfully disciplined a shop steward who had made debasing and sexually abusive remarks to a female employee who had crossed a picket line months earlier. So again, debasing and sexually abusive remarks to a specific person, literally sexually harassing them. And in Honda of America Manufacturing, the employer lawfully disciplined an employee for distributing a newsletter in which he directed one named employee, again a specifically targeted employee, to come out of the closet and use the phrase "bone us" to critique the employer's bonus program. I'm guessing his bonus was not strong. The board concluded that such language was unprotected because of its highly offensive nature and quoted approvingly an earlier decision. In view of the controversial nature of the language used and its admitted susceptibility to derisive and profane construction, the employer could legitimately ban the use of provocative language as a reasonable precaution against discord and bitterness between employees and management, as well as to assure decorum and discipline in the plant. Oh, there's a footnote. Let's see what that says. So this is quoting Southwestern Bell. See also Veterans Administration. Finding racial stereotyping unprotected and upholding employer's discipline of union president for calling a manager the spook who sat by the door and an Uncle Tom in union newsletter advocating his removal. So again, targeting a specific employee and calling him racial epithets. Detroit Medical Center. Advice memorandum dated January 10th, 2012. White employee at majority black facility who, after having been demoted due to coworker complaints, made Facebook posts about jealous-ass ghetto people that I work with and complained that the union was protecting generations of bad, lazy, piece-of-shit workers, was not engaged in protected activity, while the employee's complaints implicated Section 7 concerns. His use of racial stereotypes and slurs were opprobrious and led to a serious disruption at work and to an increase in racial tensions. Now, is calling a bunch of black employees a bunch of ghetto people, jealous ghetto people, is that the same as saying women across cultures self-report as having higher levels of neuroticism? Is that the same? This is the question. Like, these are the citations they chose. These are the closest things that they thought were the most persuasive. Let's remember that that's always a lawyer's intention with a citation, is to pick the most persuasive citation, the friendliest. The charging party's use of stereotypes based on purported biological differences between men and women should not be treated differently than the types of conduct the board found unprotected in these cases. So they're saying that his use of stereotypes based on purported, and when they say purported, what they mean is scientifically backed and sourced in his memo. Whether you think the science is settled or not is one thing. That's a fine discussion to have. But there is significant scientific research on these topics that comes to this conclusion. There may be scientific research that comes to other conclusions. I'm not a clinical psychologist or psychiatrist. I don't have a PhD in those fields, so I don't know. I don't know if there is or not. What I do know is that there is, because I just showed you at least one study supporting James Damore's position, and that is not, it's cited on Wikipedia. Wikipedia has the ability, you have the ability to challenge citations, challenge quotations. If you think that's a debunked study, it can be unwritten. Okay. Should not be treated differently than the types of conduct the board found unprotected in these cases. His statements about immutable traits, again, he doesn't say they're immutable, linked to sex, such as women's heightened neuroticism and men's prevalence at the top of the IQ distribution, which he doesn't say, were discriminatory and constituted sexual harassment. Notwithstanding his effort to cloak his comments with scientific, in quotes, references, except they're actually links to either scientific studies or Wikipedia sections backed by scientific studies with references. Check them. Check his footnotes. And analysis. Scientific references and analysis are generally used to back up points about scientific claims. And notwithstanding his, quote, not all women disclaimers. Moreover, these statements were likely to cause serious dissension and disruption in the workplace. Were they likely to cause serious dissension and disruption in the workplace? Indeed, the memorandum did cause extreme discord, which the charging party exacerbated by deliberately expanding its audience. I'm pretty sure the discord didn't occur until he expanded his audience beyond his own internal echo chamber. Right? That's not an exacerbation. And this is entirely conjecture, by the way, because we don't have any facts to support what is said here. Not at all. Numerous employees complained to the employer after he posted it on the skeptics board, which is after he increased his audience. Remember what I said earlier about those little biases that sneak in, specifically about saying that he was trying to increase his audience? And then lo and behold, they have deliberately expanding its audience. What they're trying to do, and they may not be conscious of this, right? Like lawyers write persuasively. That's how we're trained. They may not be conscious of this persuasive writing, but they're trying to persuade the reader to determine that James Damore is motivated by his audience numbers. That's what's causing him to do this. That's discrediting him. That's what they're trying to do. Whether consciously or unconsciously, that's the effort in the language here. Numerous employees complained, to the employer that the memorandum was discriminatory against women, deeply offensive, and made them feel unsafe at work. Yeah, lots of things make people feel unsafe that no reasonable person should find unsafe. But, okay. Moreover, the charging party reasonably should have known that the memorandum would likely be disseminated further, even beyond the workplace. Why would he do that? Why would he do that? How often are internal Google documents leaked to the media? This is the first I've ever heard of it. That doesn't mean it's the first it's happened. It's the first I've ever heard of it. So why should he have known that? Is this a common thing? How do you back that up? Once the memorandum was shared publicly, at least 2 female engineering candidates withdrew from consideration. He didn't share it publicly, by the way. He didn't do that. Someone else did. at least, and they only shared portions of it with overtly leftist publications, which took the quotations from it out of their context, and like this memorandum, stated things that he didn't say. And they explicitly named the memo as their reason for doing so, for withdrawing from consideration. Thus, while much of the charging party's memorandum was likely protected, the statements regarding biological differences between the sexes were so harmful, discriminatory, and disruptive as to be unprotected, despite the fact that several PhDs in the field think them to be true. Despite the fact that they're self-reported by women across cultures, according to the study I showed you before. Despite the fact that this is an open question in psychology, and it is not an unacceptable position within the field. The employer demonstrated that the charging party was discharged only because of his unprotected discriminatory statements. They didn't demonstrate that. They stated that. They said it. This is the defense in every single discrimination case. In every single discrimination case, the defense is, no, we did it for a different reason than the illegal one. Like, as if this were surprising. Remember back to their talking points. They literally said, we fired you for the discriminatory statements. They don't quote the discriminatory statements. They don't even reference them. They just said, we fired you for discriminatory statements, not non-discriminatory statements that would be illegal for us to fire you for. That's what they said. That doesn't mean that they did that. And not for, like, if we did that, by the way, I say by the way a lot, I apologize. But by the way, if we allowed this argument, we would still have, presumably, some businesses engaging in open segregation. This was the argument of segregation. And the recently following Civil Rights Act firings where they would fire black people, all of the black people. They would fire all of them. And then they'd say, well, you know, we don't like grape soda's disruptive, to use a stereotype, right? And we have a policy against grape soda because it stains the carpets, okay? Yeah, that's a tongue-in-cheek thing. Chill out, okay? They do this with old people. Age discrimination is a currently trending topic. Older workers who get paid a lot, all of them suddenly get fired, and it turns out all of them were doing this one thing that's against a company policy. But why is it only old people getting fired? In this case, why is Damore getting fired and not the guy who directly threatened and threatened him by email? Like, promising to attempt to interfere with his employment, and then offering an FU to close it out. That guy wasn't fired, Damore was. What's the difference? Could it be ideology? Maybe not. And not for expressing a dissenting view on matters affecting workplace conditions or offering critical feedback of its policies and programs, which were likely protected. Yeah, those were protected. Actually, I would say the entirety of the memo is protected by California law. I don't know if any of it's actually protected by NLRB, but they're assuming for the sake of argument that they do have authority here. The employer carefully tailored the message. Of course it did. It's called CYA. Of course they carefully tailored the message it used in discharging the charging party. Maybe a little too much, right? As well as its follow-up messages to all employees to affirm their right to engage in protected speech while prohibiting discrimination or harassment. To say while they don't fire you for your opinions while firing someone for their opinions. You ask right-leaning employees at Google. This lawyer who wrote this memo should go interview right-leaning employees at Google and find out if they feel like their position is adequately protected. Ask if they feel safe affirming their protected speech, which would be to criticize Google's political position. Ask if they feel safe in doing that. Here's a hint. They don't. In fact, the employer disciplined another employee for sending the charging party a threatening email. They gave him a warning, a final warning. They didn't fire him. In response to the views he expressed in his memo, because the employer discharged the charging party only for his unprotected conduct while it explicitly affirmed his right to engage in protected conduct, his discharge did not violate the act. And remember this. When you hear an employer say, I'm not firing you because you're black, I'm just firing you because the slang language you use around the office. Sorry. Then he gets the next person in the room. I'm not firing you because you're black, I'm just firing you for the slang language you use around the office. Accordingly, the region should dismiss this charge absent withdrawal. Of course, it was withdrawn, so that's not an issue. But honestly, this NLRB memo is a joke. It's disgusting. But the NLRB is a communist organization, right? I actually don't think that's very hyperbolic even. The NLRB promotes unions. They're overtly leftist. NLRB almost always leans heavily to the left. Unions lean heavily to the left. This is not a surprise. This is not a surprise. The only thing that's surprising is that they weren't better in hiding their biases in this memo. They come through pretty clearly. Long and short of all this is I obviously think this is a joke. Now, what effect does it have on the case? Because I promised to talk about this. It has no technical effect on the case. This is an advice memorandum. It's for the National Labor Relations Act. None of this is cited in the class action lawsuit. This will not have any effect on the legal claims in the class action lawsuit. This is a public opinion piece. Like, that's what this memorandum is. This is maybe an attempt to sway the California judge in the way that they think they're going. They're putting pen to paper saying that he had unprotected speech, but it's an opinion piece by a lawyer. This is not a ruling from a judge. This lawyer is not impartial in this action at all. And may not have even had jurisdiction to issue this ruling. I personally think this memo should have been written stating that their conduct was obviously not concerted for the purposes of mutual aid and protection, and it doesn't belong before NLRB. But they didn't do that. They issued this memo anyway, and yeah, we'll see. It can't be used in the class action claims, but it is being used to sway political opinion. Note all of the headlines saying James Damore lost his lawsuit against Google, or lost his complaint against Google, or lost his case against Google, or dropped his case against Google. All of those things. NLRB put smackdown on racist James Damore. Any of those things. That's what this is being used for. It's not correct. It has nothing to do with his class action lawsuit, and his class action lawsuit will proceed as it has been, and this should not have really much effect on it at all. But it is frustrating to see them issue this memorandum in this way, because it deliberately misreads his memo, and that's been the claim from the get-go. From anyone who's actually read his memo at the start, and isn't overtly ideologically opposed to him, would say, yeah, his memo doesn't say any of that. His memo doesn't make those claims. And if we read it at all charitably, it looks like a guy who's genuinely trying to promote diversity at Google, but is also maybe concerned that his class is in the minority and is at risk. That's what it looks like. It looks like someone who's scared, and if you haven't been in the corporate world and haven't experienced this, you may not get it. I have. I worked at 2 financial institutions prior to becoming a lawyer, and in both of them, they had overt policies to promote women and minority candidates over white male candidates. And I'm going to say that's fine. And what I mean by that's fine is I don't really care that they had that. But I had no illusions that I would be promoted in those places. Actually, in one of them, despite receiving the highest reviews in my department, the highest reviews possible in my department, I was unable to be promoted, while other candidates who maybe fit different class descriptions were. And that's the ropes. That's the ropes. I wasn't what they were looking for, even if it was my skin tone or my gender that was causing that. That's how it was. But every one of my managers at both of those jobs were female, all of them. And actually, you had to go several levels above where I was to get to a male of any type. I don't particularly care. That doesn't bother me. But it was interesting observation because they had these direct policies to promote women over men. And I literally felt like I did not have the same chance at getting promoted as I would have if I were a female. I was technically discriminated against. But, whatever. Like, that's how it goes. But I only bring this up to let you know that this isn't limited to Google, and that it is possible for a white man in a corporate setting to think that he does not have a future advancement arc, because some white men in those settings don't. Actually, many white men in those settings don't, especially when your company overtly states, we're not looking for white male candidates to advance. They may advance white male candidates because that's what they end up with, and they find the most suitable person, and that's who it is. That doesn't prevent the discrimination. The discrimination happens early on when you're told that if you're a white male, maybe don't apply for that job because maybe we're looking for a woman or we're looking for a minority to fill it. And that's what Google is doing. So bringing this back to where I started the rant, in the context of a guy who's maybe scared that all of his skills won't be recognized and instead he'll only be seen as a race and a gender, his memo makes perfect sense. It isn't actually that offensive. And I'm going to say objectively, it's not offensive at all. And subjectively, no reasonable person should find it offensive. Now, I know a bunch of people at Google found it offensive. And if you look at them, and when I say look at them, I mean look at their online activity, their Twitter accounts and stuff like that, try and find them to be reasonable. It's a challenge. I find them to be completely unreasonable in many capacities. But, that's me. You may find differently. Anyway, I'm rambling on. We're at almost an hour and 10 minutes. Let me wrap this up by an hour and 10 minutes. Thank you so much for watching. As you can see in my right there, there's a Patreon link. If you like this type of video, if you like my other videos, come visit me on Patreon. If you're looking for an audio RSS, subscribe to me on Patreon. You get access to audio RSS feeds. You don't have to subscribe to me on Patreon to do that. I love Patreon subscribers. But if you don't want to subscribe on Patreon, if you don't want to pay me money, that's fine. Check me out on Google Play. Check me out on the iTunes podcast app. You can search for Lawsplaining and find it. I don't know. I heard I was having trouble being found on the Google Play Store under Lawsplaining. So maybe check Nick Rekieta or Rekieta Law under there, and I will work on that tag and make sure that Lawsplaining is working. Otherwise, you can find me on SoundCloud, soundcloud.com/Lawsplaining. All these links are in the description, by the way. So you can find all of them there. Hit me up on Facebook, Twitter, whatever. Follow me or not. Send me messages or not. I will respond. Drop comments in the YouTube section if you like it. If you like this video, share it with someone. And let's have a discussion about this in some sort of way that fits my style. Other people are discussing it in other styles, and who cares? But discuss it in my style because that's fun. Anyway, thanks for watching this video. Thanks for joining me. I really appreciate it. Hope you found it insightful, educational, or entertaining, one of them. If not, tell me in the comments what you'd like to see. I will continue to cover this case, and check out the other cases we're covering because some of them are really funny. Thanks for watching. Have a great night.